Good evening, everyone. Welcome back to the YouTube channel of RankersBuzz. Today, we'll discuss about a very important judgment and a topic. So, before going into the judgment, we'll discuss a brief about it, the background of this. So, we know that in the recent years, we have been discussing a lot about the freedom of speech and expression, and also the fake news, which it's spread like anything, because in the age of the social media, any news which comes up, it goes hand in hand very at a very faster pace because of the social media. Because once a person posts some kind of thing, either it is right news or fake news or whatever it is, it's gets around very easily, and it goes to a lot of people, crores of people watch that news, and nobody bothers to take care of that ki bhai wo sahi hai ki galat hai. Nobody is actually bothered about that. So a lot of things happening in the last few years about the fake news since this emergence of the social media in the hands of people. जब से इतना ज्यादा जो है हर किसी के हाथ में सोशल मीडिया है, फेक न्यूज के फैलने की जो है तादाद वो भी काफी तेजी से बढ़ी है. And in that only, many people, many news agencies, or certain specific channels working to just see that what are the different fake news, and they try and tell people that these are the fake news. They investigate those news and tell people about that, how, why it is fake and how it has been propagated to you. So these kind of activities are also taking place. So when it comes to the freedom of speech and expression, we all know that this is mentioned under Article 19 of the Indian Constitution. अगर हम बात करें Article 19, but yes, again, when it comes to the Article 19, it says, yes, you have all freedom of speech. You can speak anything. You can, post anything on the Twitter, Instagram, Facebook, or anywhere you like. You can roam around the country. You can do any kind of professional work. You can, settle in any part of the India. This has been said by Article 19. But at the same time, the rights given in 19 clause 1 has been restricted by 19.2, because no right is absolute in nature. We know that we have been given fundamental rights, but fundamental rights are not absolute in nature. You cannot be like, just use that, fundamental rights in arbitrary manner. There are definitely certain restrictions being put up on these rights, these fundamental rights, in the form of, like, if it is threatening the security of the country, sovereignty of the country, or the peace in the country, then definitely that freedom of speech will not be allowed. That freedom of speech and expression can be restricted. So such provisions are given under our constitution, and especially under Article 19. So in Article 19.1, it gives right to the people, and in 19.2, it has certain reservations to it, and certain restrictions are there in the Article 19.2. And this is very much related to the fake news. Like, whether we have the freedom of speech, but freedom of speech क्या fake news फैलाने का भी है? या फिर अगर कोई इस फेक न्यूज का जो है यहाँ पे इस बात का सोल्यूशन निकालता है कि ये फेक न्यूज है या फेक न्यूज नहीं है, अगर इस बात को बताता है, तो वो क्या एंटाइटल्ड है बताने के लिए कि भाई ये बात जो है वो फेक न्यूज नहीं है? क्या इसके पास जो है ये आर्टिकल 19.1 का इस्तेमाल सही कर रहा है, या फिर वो जो इस बात को फैला रहा है वो उस बात का सही इस्तेमाल कर रहा है? इस बात के अंदर जो है डिफरेंस समझना बहुत जरूरी है. एंड इन द लास्ट मेनी इयर्स वी हैव सीन मेनी एक्टिविस्ट going behind the bars, after posting something on the social media, doing something on the YouTube, a lot of scrutiny is being there. So to what extent this scrutinization by the state is valid under 19.2, and whether it is actually suppressing the voice of individuals, independent individuals who are doing their job. So this question has been raised in the today's judgment also that we are going to discuss. This is a very landmark judgment. But the matter was related to the fake news and the freedom of speech. But present case was actually filed for the bail. Bail application was filed, whether that bail should be allowed or not. We'll go into the facts and know that what exactly been asked in this judgment. क्या पूछा गया था और कोर्ट ने क्या इसके अंदर यहाँ पे बोला है. So that we will see here. So the today's judgment is the Mohammed Zubair versus State of NCT Delhi 2022. And this case was heard by Justice G.Y. Chanchud, Justice Suryakant, and Justice A.S. Bopanna. This was a three-judge bench which was hearing this particular case. So here what happened that this Mr. Mohammed Zubair, he was the co-founder of the Alt News. You all must be knowing Alt News is a news channel which actually works or investigates the fake news. It actually do the fact checking. They check the fact checking of the news which is running around. उसको check करते हैं कि भाई क्या वो fake है या नहीं है. They investigate that part of news. So here, the petitioner Mohammed Zubair was a co-founder of Alt News, a fact-checking website run under the authority of Pravda Media Foundation. So there is a Pravda Media Foundation under which this Alt News is actually running, and this is basically a website, run news in which the fact-checking is done by the people working for this particular news channel. Now, the petitioner here, what this petitioner, that is Mohammed Zubair, did in this case. So the petitioner used his social media platform, Twitter. यहाँ पे इन्होंने जो है Twitter, जिसको आप X बोलते हैं, इसका नाम चेंज करके X कर दिया गया है, as a medium of communication to dispel false news and misinformation being spread through morphed images, clickbaits, and tailored videos. So what exactly he did, इन्होंने क्या किया कि ट्विटर के थ्रू जो इन्वेस्टिगेशन इन्होंने की थी उसका कम्युनिकेशन लोगों को इन्होंने ट्विटर के थ्रू किया और वहां पे बताया कि ये जो पर्टिकुलर न्यूज है ये फॉल्स क्यों है, ये मिस इन्फॉर्मेशन जो है ये क्यों फैलाई जा रही है, उसको उन्होंने फैक्ट चेक करके वहां पे डाला. which includes certain morphed images. कुछ images के साथ छेड़छाड़ थी, उनके साथ जो है images को थोड़ा edit करके वहां पे दिखाया गया था जिसकी वजह से फेक न्यूज फैल रही थी. There were certain bites, there were certain videos which were tailored. कुछ छेड़छाड़ करके उन videos को spread किया जा रहा था to spread hatred in the society, to spread fake news in the society. So that was investigated and he put that on the social media. And petitioner did it in a series of tweets being done by him. The petitioner had put out a series of tweets on Twitter. बहुत सारे series of tweets जो है वो वहां पे Twitter पे डालते हैं. Then claiming that the petitioner had posted such tweets to trigger religious sentiments. तो अब यहाँ पे जो है the special cell of Delhi police, the Delhi police actually says that the petitioner has posted these tweets to trigger the religious sentiments. उनका ये कहना है that these tweets are being set out to, to trigger the religious sentiment of certain section of people on June 20th, 2022. The special cell of Delhi police registered FIR against the petitioner on alleged offences punishable under section 153A. So there were multiple FIRs being made, and in one of the FIRs, different sections which have been put against him was section 153A, which talks about the promoting enmity between different groups on grounds of religion, race, place of birth or residence. कि भाई आप जो है enmity फैला रहे हैं different groups के बीच में based on their religion, race, caste or place of birth. Again, the next section is 295A, deliberate and malicious act intended to outrage religious feelings of any class by insulting its religion or religious belief. दूसरा जो यहाँ पे सेक्शन लगाया गया उसमें बताया गया कि आप जो है धार्मिक भावनाओं को भड़काने की कोशिश कर रहे हैं, उसको इंसल्ट करने की कोशिश वहां पे कर रहे हैं. नेक्स्ट इज दी सेक्शन 201 ऑफ द आईपीसी, दैट इज गिविंग फॉल्स इंफॉर्मेशन, कि आप जो है गलत इंफॉर्मेशन दे रहे हैं. एंड सेक्शन 120B, that is the criminal conspiracy. You are also doing a criminal conspiracy. And along with that, section 35 of the Foreign Contributions Act 2010. And there are, they have a doubt about that he is having certain foreign contributions from somewhere else. So these were some of the sections being put up against him in, different sections, the IPC as well as the Foreign Contribution Regulations Act 2010. Other than this FIR being filed by the special unit of the Delhi police, and another, other FIRs were also being lodged against him. That is there were about 6 FIRs filed in Ghaziabad, Chandoli, Lakhimpur, Sitapur, Hathras, been filed in the state of UP, has also been transferred from Uttar Pradesh Police to the special cell of Delhi Police, because the FIRs were related to the same subject. So they were also referred to the Delhi Police, they were transferred to the Delhi Police, thereby disbanding the SIT formed by Director General of Police Uttar Pradesh on 10 July 2022. और ये सारी जो यहाँ पे FIR थी, इनको जो है दिल्ली पुलिस के पास ही ट्रांसफर कर दिया गया, जिस वजह से जो SIT DGP उत्तर प्रदेश पुलिस ने जो फॉर्म की थी, वो वहां पे जो है उसका कोई मतलब नहीं रह जाता और वो रद्द कर दी जाती है. If any other related FIR is filed against Zubair, then the same will also be transferred to the special cell of the Delhi police and Zubair shall be entitled to the interim bail. और कहा गया कि भाई जितनी भी पिटीशन जगह जगह चल रही है उसको एक जगह ट्रांसफर किया जाए, दिल्ली के अंदर दिल्ली पुलिस को दिया जाए और तब तक जो है इंटरिम बेल इनको दे दी जाए. Because there is only an allegation, there is no as such being things being proved. As far as the FIR registered at Muzaffarnagar is concerned, wherein the charge sheet under 173 of the CRPC has been filed, charge sheet भी मुजफ्फरनगर में फाइल कर दी गई थी. The court transferred the proceeding to the Chief Judicial Magistrate, Patiala House Court. उसको भी मुजफ्फरनगर कोर्ट्स के जो मैजिस्ट्रेट थे, चीफ जुडिशियल मैजिस्ट्रेट, उन्होंने इस पर्टिकुलर जो केस था इसको भी यहाँ पे पटियाला हाउस कोर्ट में दिल्ली में ट्रांसफर कर दिया. And directed the matter is to be taken up from the stage that has reached before the earlier court. जहां पे मैटर चल चुका है उससे आगे अब पटियाला हाउस कोर्ट में ये मैटर चलेगा, ऐसा यहाँ पे ट्रांसफर करते समय बोला गया. The petitioner has been enlarged on bail, और जो petitioner है उनको यहाँ पे bail आगे भी मिली, regular bail मिली. The order enlarging the petitioner on bail shall continue to remain in force. कोर्ट कहता है कि जो यहाँ पे उनको बेल दी गई है, बढ़ाई गई है, वो बेल यहाँ पे लागू रहेगी, वो बेल कैंसिल नहीं की जाएगी. Unhappy with the acts of the police in the case, the court was not very happy with the act being done by the police. Court went on to observe that the machinery of criminal justice has been relentlessly employed against the Zubair. यहाँ पे कोर्ट ने देखा कि भाई जो आपकी क्रिमिनल जस्टिस की जो मशीनरी है, this has not been used against Zubair in a good faith. And despite the fact that the same tweets allegedly gave rise to similar offense in the diverse FIR mentioned above, the petitioner was subjected to multiple investigations across the country. So how can this be कि भाई same tweet having the allegedly similar kind of offenses filed in the FIR and he's been investigated across the country. आप different अलग अलग जगह पे जो है investigate कर रहे हैं same matter same tweet को. And he's been there कि भाई कभी वो वहां पे जाए कोर्ट की हियरिंग में, कभी वहां पे जाए, कभी इन्वेस्टिगेशन के लिए वहां जाए. If the matter is same, then why not to decide on the in one court in the one city? Consequently, he would be required to hire multiple advocates across district. अब इसका मतलब तो इन्हें हर डिस्ट्रिक्ट में जहां जहां केस फाइल होगा वहां अलग अलग एडवोकेट इनको लेने पड़ेंगे, वहां पे एम्प्लॉय करने पड़ेंगे. Then file multiple applications for bail, और हर जगह वो bail application file करे. Travel to multiple districts spanning 2 states for the purpose of investigation. और जहां जहां investigation के लिए बुलाया जाए सब जगह जाते रहें. And defend himself before the multiple courts, all with respect to substantially the same alleged cause of action. Same cause of action, same case, same tweet, same FIRs, but different state, different districts. So how can it be possible for one man to travel this long? कभी यहाँ कभी वहां वो कैसे जाएगा? This question was raised in this particular judgment by the court. Resultantly, the court noted that the Zubair has been trapped in a vicious cycle of criminal process where the process has been itself become the punishment. तो कहते हैं कि जुबैर जो है एक तरीके से यहाँ पे एक ट्रैप में फंस गए क्रिमिनल जस्टिस प्रोसेस के, जिसके अंदर कि उनको इस प्रोसेस को झेलना ही एक तरीके का पनिशमेंट हो गया है कि आज वो यहाँ जा रहे हैं, कल कहीं और जा रहे हैं, परसों कहीं और जा रहे हैं. पूरे दिन जो है इन्वेस्टिगेशन और कोर्ट के ही चक्कर काट रहे हैं, उसके अलावा वो कुछ नहीं करे, इवन दो द बेल हैज बीन ग्रांटेड. द कोर्ट हेंस ऑब्जर्व्ड दैट, कोर्ट यहाँ पे ऑब्जर्व करती है that the arrest is not meant to be and must not be used as a punitive tool because it result in one of the gravest possible consequence emanating from the criminal law. तो कहते हैं दी अरेस्ट जो है उसका मतलब ये नहीं है कि भाई आप उसको एक टूल की तरह इस्तेमाल करने लगे कि भाई उस सामने वाले को परेशान करने के लिए. द लॉस ऑफ पर्सनल लिबर्टी, कि भाई उसकी पर्सनल लिबर्टी वहां पे जाती है. Because once you are into the cases, multiple cases, you don't have personal liberty, राइट। इंडिविजुअल्स मस्ट नॉट बी पनिश्ड सोनली ऑन द बेसिस ऑफ एलिगेशंस, कहता है कि सिर्फ एलिगेशंस के बेसिस पे आप किसी को पनिश नहीं कर सकते हैं इस तरीके से, एंड विदाउट अ फेयर ट्रायल। एंड ऐसा कोई फेयर ट्रायल वहां पे भी फिलहाल होता हुआ दिखाई भी नहीं दे रहा है। When the power to arrest is exercised without application of mind and without a due regard to the law, it amounts to the abuse of power. पुलिस को कहते हैं कि भाई जब आप जो है अरेस्ट जो है उसको इस तरीके से करते हैं कि भाई बिना एप्लीकेशन ऑफ माइंड के, आप जो है दिमाग का बहुत ज्यादा इस्तेमाल बिना किए जो है उसमें अगर अरेस्ट वहां पे करते हैं, एंड व्यू विदाउट ड्यू रिगार्ड टू लॉ, कानून क्या कहता है इसके बारे में बहुत ज्यादा बिना सोचे समझे अगर आप यहाँ पे जो है उसका इस्तेमाल करते हैं पावर का, देन डेफिनेटली वी कॉल इट द अब्यूज ऑफ पावर, हम उसे अब्यूज ऑफ पावर ही कहेंगे। दिस इज व्हाट बीन सेड बाय द कोर्ट हियर, stating that the police officers are expected to apply their minds to the case before them। कहते हैं कि जो भी केस पुलिस के पास आए उसके अंदर एटलीस्ट अपना जो माइंड है उसको वहां पे कुछ तो इस्तेमाल किया जाए। The court further said the criminal justice and its process ought not to be instrumentalized as a tool of harassment। कहते हैं जो क्रिमिनल जस्टिस प्रोसेस है उसको किसी को हैरस करने के लिए हम इस्तेमाल ना करें। Section 41 of the CRPC as well as the safeguard in the criminal law exist in recognition of the reality that any criminal proceeding almost inevitably involves the might of the state with unlimited resources at its disposal against the alone individual। कहते हैं कि स्टेट के पास तो बहुत सारी चीजें होती हैं, हर रिसोर्स है सामने वाले को जो है कटघरे में खड़े करने के लिए या उसको परेशान करने के लिए, लेकिन जो एक आदमी अकेला खड़ा है उसके पास इतने ज्यादा ना ही रिसोर्सेज है ना ही उसके पास इतने सारे जो है कुछ उसके पास ऑप्शंस बच जाते हैं अगर उसके पीछे क्रिमिनल जस्टिस सिस्टम का इस्तेमाल इस तरीके से किया जाता है। दिस इज बीन सेड बाय द कोर्ट। Further, it says, when the state of Uttar Pradesh attempted to persuade this court that the petitioner must be barred from tweeting when he is on bail, तो कहते हैं कि उत्तर प्रदेश स्टेट ने कोर्ट को अप्रोच किया यहाँ पे सुप्रीम कोर्ट को और कहा कि इनको बेल जो दी गई है जब ये बेल पे है उस दौरान ये किसी प्रकार का ट्वीट ना करें। तो अब कोर्ट इस पे क्या कहता है कि भाई क्या कोई बेल पे है तो क्या वो ट्वीट ना करे, क्या इस पे ये बात सही है गलत है? कोर्ट कहता है कोर्ट हेल्ड that merely because the complaint filed against the petitioner arise from the posts that were made by him on a social media platform, a blanket anticipatory order preventing him from tweeting cannot be made। तो कहते हैं जस्ट बिकॉज कि किसी के ऊपर कोई कंप्लेंट हुई है तो उसकी वजह से वो आगे से कोई सोशल मीडिया पे पोस्ट करना बंद कर दे या उसके ऊपर परमानेंट रोक लगा दें, ये बिल्कुल भी सही वहां पे नहीं है। इट इज अगेंस्ट द फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन। A blanket order directing the petitioner to not express his opinion, an opinion that he is rightfully entitled to hold as an active participating citizen। एक participating citizen है उसको सारा right है कि वो अपने views को जो है express कर सके, would be disproportionate to propose on imposing conditions on bail। कहते हैं कि बेल की कंडीशन पे हम ये यहाँ पे नहीं लगा सकते, अदरवाइज वो बहुत डिस्प्रोपोर्शनेट दिखाई देगा। The imposing of such a condition would tantamount to a gag order against the petitioner। वो बहुत ही गलत ऑर्डर होगा। गैग ऑर्डर हैव अ चिलिंग इफेक्ट ऑन द फ्रीडम ऑफ स्पीच और ये फ्रीडम ऑफ स्पीच के खिलाफ दिखाई देगा। Noticing that Zubair is a journalist who is a co-founder of the fact-checking website and uses Twitter as a medium of communication to dispel false news and misinformation in this age of morphed images, clickbaits, and the tailored videos। अब इस टाइम में जहां पे कि वो एज अ फैक्ट चेकर काम कर रहे हैं वेबसाइट के लिए, को फाउंडर हैं एक फैक्ट चेकिंग वेबसाइट के, वो ट्विटर को यूज करते हैं कम्युनिकेशन करने के लिए, फॉल्स न्यूज के बारे में लोगों को बताने के लिए। सो कैन वी स्टॉप हिम? द कोर्ट हेल्ड दैट पासिंग एन ऑर्डर restricting him from posting on social media would amount to an unjustified violation of the freedom of speech and expression। कहते हैं कि बिल्कुल जो है फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन का जो है यहाँ पे उल्लंघन दिखाई देगा अगर हम ऐसा कोई ऑर्डर देते हैं। एंड फ्रीडम ऑफ प्रैक्टिस इज प्रोफेशन, और उसका प्रोफेशन है, otherwise it will be violative of Article 19। The observation came after it was noted that bail conditions imposed by the court must not only have an access to the proposed purpose that they seek to serve, but must also be proportional to the purpose of imposing them। तो कहते हैं जब भी बेल की कंडीशन लगाई जाए तो उसके अंदर दोनों में नेक्सस देखा जाए कि पर्पस क्या है बेल देने का। ठीक है, ऐसा नहीं कि बेल देने की कंडीशन में हम उसकी लाइफ को ही रोक दे, जो उसका काम है वही रुक जाए। The court, while imposing bail conditions, must balance the liberty of the accused and necessity of the fair trial। तो जब भी बेल की कंडीशन लगाई जाए तो वहां पे देखा जाए, उसकी लिबर्टी का ध्यान दिया जाए और फेयर ट्रायल कैसे हो सकता है वैसे यहाँ पे जो है जो भी इम्पोज करना है, जो नेसेसिटी इम्पोज करनी है वो उसी तरीके से की जाए कि फेयर ट्रायल हो सके एंड अक्यूज की लिबर्टी का भी ध्यान रखा जाए। While doing so, the conditions that would result in the deprivation of rights and liberties must be assured. इस सब चीज से हमें बचना चाहिए कि हम जो है किसी के लिबर्टी से डिप्राइव कर दें, उसे उसके जो फंडामेंटल राइट्स हैं उससे डिप्राइव कर दें, ऐसा हमें यहाँ पे नहीं करना है. So this is what we understand out of the judgment, that a criminal justice system must not be used to, harass someone and, multiple FIRs against one person if somebody is using a social media. And again, putting a condition of bail कि भाई आप सोशल मीडिया यूज नहीं करेंगे, this cannot be one of the conditions when it comes to his profession. He's a profession, he's into a profession where it is his work to, fact check and put those things in the social media to let people know that what is right and what is wrong. So in this judgment, it was again a very important judgment when it comes to the imposing the conditions of bail. Bail conditions की बात करें तो this was again a very important judgment with respect to bail conditions and the freedom of speech and expression, right? And also with respect to the fake news, which is very much prevalent in nowadays, because of the social media. So this is how we understand this particular judgment. This is a very important judgment, may be asked in some of the examinations. So it is important that they look after this particular judgment, study this judgment, observe this judgment, and try and remember the name as well. So I hope you all have understood this. Thank you so much. Thank you for joining, and keep subscribing our channel so that you get an update about all these upcoming judgments. Thank you. Good night. Take care. Bye-bye.